Hello, my name is Dorit Reiss. I'm a professor of law at the University of California, Hastings College of the Law. I want to explain why courts in the United States have consistently found that school mandates do not violate the Free Exercise Clause, the clause that protects your ability to exercise your religion freely. There's two parts to that, and then I'll address a couple of counters. First, our general approach to the First Amendment is that states do not have to give a religious exemption from generally applicable neutral on their face laws that are not targeted at religion. The state does not have to give you an exemption from tax laws, even if you have religious opposition to paying taxes. The state does not have to give you a religious exemption from substance laws, even if you're using the substance in a religious ceremony, and the state does not have to give you a religious exemption from school mandates. The leading case of that is Employment Division versus Smith from 1990. Second, for school mandate, we have an even older jurisprudence that says that states can impose school mandates and do not have to exempt parents who have religious objections. The leading case on that is Prince versus Massachusetts from 1944 from the Supreme Court. And the rationale there is that school mandates protect the child because the risks of vaccines are small and much smaller than the risks of not vaccinating. The risk to the child of not vaccinating is getting a preventable disease. And they protect the community by reducing the risk of outbreak. The parent's religious objection does not allow the parent to place the community at risk or even the child at risk when that's preventable. Two objections that can come up. First, some states have Religious Freedom Restoration Act, which require laws that violate religious freedom to meet a higher burden of strict scrutiny. However, school mandates protect against outbreak. Outbreaks of preventable diseases can cause death, harms. Preventing those things is a compelling interest, and often there's no good alternative to a mandate. So even with a strict scrutiny standard, courts have upheld school mandates. Second, in a recent case in New York, attorney Michael Zussman tries to raise an argument that the legislator was acting out of hostility to religion when the legislator overturned the previous law that allowed the religious exemption. That was built on a Supreme Court case that found that the Colorado Civil Rights Commission, when it penalized a baker who refused to make a cake for a same-sex couple, was acting out of religious animosity. But the courts in New York rejected that, partly because they said convincingly that courts should be cautious in focusing on individual legislators' statement when they're trying to assess general legislation. There are many people in the legislature, and you can always find a statement that you can point to for many things. And partly because the statements in question were mostly statements that said, well, we suspect that many of the religious exemptions are insincere. Most religions support vaccines, or at least do not prohibit them. There are some people who have religious objections to vaccine, but studies suggest that most people who oppose vaccine do that out of misguided safety concerns. So the court rejected the claim based on animosity. In over 100 years, courts, state and federal, consistently upheld school mandates against claims based on religious freedom correctly, and they're likely to continue doing so. Thank you.